And that is definitely a difference that distinguishes this market and justifies this as a regulation.
All right, so if that is your
difference,
I'm somewhat uncertain about your answers to, for example, Justice Kennedy asked, can you, under the Commerce Clause, Congress create commerce where previously none existed?
Well,
yeah, I thought the answer to that was, since McCulloch versus Maryland, when the court said Congress could create the Bank of the United States, which did not previously exist, which job was to create commerce that did not previously exist. Since that time, the answer's been yes. I would have thought that your answer can the government, in fact, require you to buy cell phones or buy burials, that if we propose comparable situations, if we have, for example, a uniform United States system of paying for every burial, such as Medicare burial, Medicaid burial, CHIP burial, ERISA burial, and emergency burial beside the side of the road, and Congress wanted to rationalize that system, wouldn't the answer be yes? Of course they could. And the same with the computers, or the same with the cell phones if you're driving by the side of the highway and there is a federal emergency service, just as you say you have to buy certain mufflers for your car that don't hurt the environment. You could, I mean, you see, doesn't it depend on the situation?
It does, Justice Breyer, and if Congress were to enact laws like that, we
would be up here
my responsibility.
All right, so then the
defend them, and I would defend them on a rationale like that. But I do think that we are advancing a narrower rationale.
Well, then the question is whether or not there are any limits on the Commerce Clause. Can you identify for us some limits on the Commerce Clause?
Yes. The rationale purely under the Commerce Clause that we're advocating here would not justify forced purchases of commodities for the purpose of stimulating demand. It would not justify purchases of insurance for the purposes in situations in which insurance doesn't serve as the method of payment.
But why not? If Congress says that interstate commerce is affected, isn't, according to your view, that the end of the analysis?
No. We think that the difference between those situations and this situation is that in those situations, Your Honor, Congress would be moving to create commerce. Here, Congress is regulating existing commerce, economic activity that is already going on, people's participation in the healthcare market, and is regulating to deal with existing effects of existing commerce.
That, it seems to me, is, and it's a passage in your reply brief that I didn't quite grasp. It's the same point. You say health insurance is not purchased for its own sake, like a car or broccoli. It is a means of financing healthcare consumption and covering universal risks. Well, a car or broccoli aren't purchased for their own sake either. They're purchased for the sake of transportation or, in broccoli, covering the need for food. I don't understand that distinction.
The difference, Mr. Chief Justice, is that health insurance is the means of payment for health care.
Well, now that's a significant... I'm sorry.
And broccoli is not the means of payment for anything else. And
it's the means of satisfying a basic human need, just as your insurance is the means of satisfying.
But I do think that's the difference between existing commerce, activity in the market already occurring, the people in the healthcare market purchasing, obtaining healthcare services, and the creation of commerce. And the principle that we're advocating here under the Commerce Clause does not take the step of justifying the creation of commerce. This is a regulation.
Can we go back to, and Justice Breyer asked a question and it kind of interrupted your answer to my question, and tell me if I'm wrong about this, but I thought a major point of your argument was that the people who don't participate in this market are making it much more expensive for the people who do. That is, they will get, a goodly number of them will get services that they can't afford at the point when they need them, and the result is that everybody else's premiums get raised So it's not your free choice just to do something for yourself. What you do is going to affect others, affect them in a major way.
That absolutely is a justification for Congress's action here. That is existing economic activity that Congress is regulating by means of this rule.
You could say that about buying a car. If people don't buy cars, the price that those who do buy cars pay will have to be higher. So you can say, in order to bring the price down, you are hurting these other people by not buying a car.
That is not what we're saying, Justice Scalia.
That's not what you're saying. I thought it was. I thought you're saying other people are going to have to pay more for insurance because you're not buying it.
No, it's because you're going in the healthcare market, you're going into the market without the ability to pay for what you get, getting the healthcare service anyway as a result of the social norms that allow to which we've obligated ourselves, so that people
don't obligate yourself to that. Why?
I can't imagine that the Commerce Clause would forbid Congress from taking into account this deeply embedded social norm.
You can do it, but does that expand your ability to issue mandates to the people?
This is not a purchase mandate. This is a law that regulates the method of paying for a service that the class of people to whom it applies are consuming or inevitably will consume.
General, I see or have seen 3 strands of arguments in your briefs, and one of them is echoed today. The first strand that I've seen is that Congress can pass any necessary laws to affect those powers within its rights, i.e., because it made a decision that to affect mandatory issuance of insurance, that it could also obligate the mandatory purchase of it. The second strand I see is self-insurance affects the market, and so the government can regulate those who self-insure. And the third argument, and I see all of them as different, is that what the government is doing, and I think it's the argument you're making today, that what the government is saying is if you pay for if you use health services, you have to pay with insurance, because only insurance will guarantee that whatever need for health care that you have will be covered, because virtually no one, perhaps with the exception of 1% of the population, can afford the massive cost if the unexpected happens. This third argument seems to be saying what we're regulating is health care, and when you go for health services, you have to pay for insurance. And since insurance won't issue at the moment that you consume the product, we can reasonably, necessarily tell you to buy it ahead of time, because you can't buy it at the moment that you need it. Which of these 3 is your argument? Are all of them your argument? I'm just not sure what
let me try to state it this way. The Congress enacted reforms of the insurance market, the guaranteed issue and community rating reforms. It did so to deal with a very serious problem that results in 40 million people not being able to get insurance and therefore not access to the health care market. Everybody agrees in this case that those are within Congress's Article I powers. The minimum coverage provision is necessary to carry those provisions into execution, because without those provisions, without minimum coverage, guaranteed issue and community rating will, as the experience in the states showed, make matters worse, not better. There will be fewer people covered. It will cost more.
So on that ground, you're answering affirmatively to my colleagues that have asked you the question, can the government force you into commerce? And there's no limit to that power.
No, because that's the first part of our argument. The second part of our argument is that the means here that Congress has chosen, the minimum coverage provision, is a means that regulates economic activity, namely your transaction in the healthcare market, with substantial effects on interstate commerce. And it is the conjunction of those two that we think provides the particularly secure foundation for this statute under the commerce power.
General, you've talked on a couple of times about other alternatives that Congress might have had, other alternatives that the respondents suggest to deal with this problem, in particular the alternative of mandating insurance at the point at which somebody goes to a hospital or an emergency room and asks for care. Did Congress consider those alternatives? Why did it reject them? How should we think about the question of alternative ways of dealing with these problems?
I do think, Justice Kagan, that the point of difference between my friends on the other side and the United States is about one of timing. They've agreed that Congress has Article I authority to impose an insurance requirement or other penalty at the point of sale, and they've agreed that Congress has the authority to do that to achieve the same objectives that the minimum coverage provision of the Affordable Care Act is designed to achieve. This is a situation in which we are talking about means. Congress gets substantial deference in the choice of means, and if one thinks about the difference between the means they say Congress should have chosen and the means Congress did choose, I think you can see why it was eminently more sensible for Congress to choose the means that it chose.
I'm not sure which way it cuts if the Congress has alternate means. Let's assume that it could use the tax power to raise revenue and to just have a national health service, a single payer. How does that factor into our analysis? In one sense, it can be argued if this is what the government's doing, it ought to be honest about the power that it's using and use the correct power. On the other hand, it means that since the court can do it anyway, Congress can do it anyway, we give a certain amount of latitude. I'm not sure which way the argument goes.
Let me try to answer that question, Justice Kennedy, and get back to the question you asked me earlier. I do think one striking feature of the argument here that this is a novel exercise of power is that what Congress chose to do was to rely on market mechanisms and efficiency and a method that has more choice than would the traditional Medicare or Medicaid type model. And so it seems a little ironic to suggest that that counts against it. But beyond that, in the sense that it's novel, this provision is novel in the same way, or unprecedented in the same way, that the Sherman Act was unprecedented when the court upheld it in the Northern Securities case, or the Packers and Stockyards Act was unprecedented when the court upheld it, or the National Labor Relations Act was unprecedented when the court upheld it in Jones and Lockwood, or the dairy price supports in Wrightwood Dairy.
Oh, no, it's not. They all involved commerce. There was no doubt that what was being regulated was commerce. And here you're regulating somebody who isn't commerce. Now, by the way, I don't agree with you that the relevant market here is health care. You're not regulating health care. You're regulating insurance. It's the insurance market that you're addressing, and you're saying that some people who are not in it must be in it. And that's different from regulating in any manner commerce that already exists out there.
Well, to the extent that we're looking at the comprehensive scheme, Justice Scalia, it is regulating commerce that already exists out there. And the means in which that regulation is made effective here, the minimum coverage provision, is a regulation of the way in which people participate, the method of their payment in the health care market. That is what it is. And I do think, Justice Kennedy, getting back to the question you asked before, what matters here is whether Congress is choosing a tool that's reasonably adapted to the problem that Congress is confronting. And that may mean that the tool is different from a tool that Congress has chosen to use in the past. That's not something that counts against the provision in a Commerce Clause.
It's both necessary and proper. What you just said addresses what's necessary.